so far. You stand still a second right there. Why, we'll be happier. That's very good.
Beautiful, Charlie.
Good morning.
Good morning.
How are you this morning?
Fine, how are you?
Representation, but in actuality, he was not allowed to defend himself.
Are you going to go ahead with the psychiatric examination?
No, we've withdrawn the psychiatric
Why?
examination. I've seen Mr. Manson in county jail for probably more than any other attorney, 70, 80 times, and it's certainly my feeling that Mr. Manson is sane. There's no question about his sanity in my mind.
Are you worried about your lack of experience at all?
No, I'm not.
Yes, Mr. Hughes Mr. Manson has authorized Mr. Hughes to act as his authorized agent before in looking at exhibits and in getting to look at the photographs and things of that nature.
Well, did it come as any surprise then that they asked him to be his attorney at long last?
Yes, I thought that Mr. Manson would choose someone else, but Mr. Hughes is a competent attorney. He's passed the bar. And unlike the practice of medicine, once you pass the bar, you're admitted to practice and you can represent someone in a capital offense or you can represent someone in a traffic ticket.
The changing of the counsel, the actions of Mr. Manson, did any of it surprise you?
Everything surprised me. I came into court expecting Mr. Holopater's motions to be granted. The motion to sever, I thought the court would take under advisement to give us an opportunity to answer. Then a change of attorneys and Mr. Manson's
Defense
contact.
theory. Mr. Hughes before. Defense?
I'll answer the United Defense and then I'll answer the question about where things stand. All you gentlemen will be back here for trial. On March the 24th, we'll be in Department 106 for a motion to change of venue.
There's a lot. I think you would have a much better shot if you weren't talking with me, but you were picking up some of the friends of Manson over there who were singing, you know.
The United Defense seems to be borne out. There was a story in the Los Angeles Times about a month ago about a United Defense. At that time, I thought that it would be against their interest to have such a defense, but it seems to me that that's what the defendants want, and they're even willing to give up their rights to go to trial at an earlier date to get it. We are prepared to meet this United Defense.
Conspiracy and 4 counts of murder?
Well, he's charged actually with 7 counts of murder and only 1 count of conspiracy.
And you feel you're capable of defending that?
That it's because of the things that the court has done that Mr. Manson was originally forced to go pro per. They wouldn't allow him to have associate counsel, and then from other things that the court has done, this has later forced the court to take that pro per status away. Mr. Manson at points was getting very close to a number of truths, exposing the system of criminal justice that we have in this country, the terrible odds that he was at. That the district attorney had these wonderful facilities in which to try and convict him and seek his death, and yet Mr. Manson had to wait for an hour and a half to make a 10-minute phone call.
Are you going to seek the pro per status again?
I would hope to get Mr. Manson's pro per status back. I imagine that will be very difficult, and it might very well be impossible.
Tell us something about yourself, Mr. Hughes.
No, not that long. 1 o'clock.
Who prepared that?
Because Manson now has another lawyer, Judge Keene extended the trial date to 1 month from now, April 20th. John Davenport, ABC News, at the Hall of Justice, Los Angeles.
Killing Indians.
Well, because of the fact of his He was raised in a reform school. He's been in prison. He's always been on the other side of the law. That's the reason. In small little matters, he's never committed any very serious crimes, stealing a car or something like that.
No violence.
No violence, that's right.
The court proceeding began for the stated purpose of ascertaining whether Mr. Manson would qualify to represent himself in pro per. He had a motion on file to ask the court that he be allowed to represent himself in pro per with the conjunction of two other counsel, Mr. Steinberg and myself. Now that was the issue at stake. Now it would seem that if the court had questions as to whether or not he was able to do this, and Mr. Manson had earlier stated as he had that he needed the assistance of legal advice to handle legal matters in court, he has never taken the position that he could act alone, that the court should have afforded him his designated counsel to assist him in responding to the questions in court today and in arguing the legal matter involved, which I think is a very novel one. The court constantly says to Mr. Manson in a misleading fashion, not intentionally so perhaps, but I think a blatant misstatement of the law, that he is waiving his right to counsel by representing himself. It is our contention that he is insisting on his right to counsel by representing himself, and at the same time may, as other defendants have done, as Jack Kursky has done, designate additional counsel to represent him.
You've talked with Mr. Manson. What kind of personality does he have? What observations did you make?
I was agreeably surprised when I talked to him because he'd been pictured as sort of a monster in the newspapers and in the magazines. I found him to be a very quiet, affable young man, a man of keen intelligence. He advises me that he's a pacifist. He's never hurt any living thing in his life and doesn't believe in any type of violence. He let me know that he had never been convicted of a crime of violence in his life.
Is it wise, Mr. Ball, for him to defend himself in this case?
I don't think so. I think he needs the services of counsel in this case, particularly because of the publicity, which is making a fair trial almost impossible in this case. I think he should have a lawyer. He's waiving a lawyer now. It was against my advice. I advised him to let the judge appoint a competent lawyer. I let him know that I was not that lawyer and that I was not there to represent him in any other way than to advise him that he should have a lawyer.
Another question. Why do you think he has so much distrust for lawyers and the law?
Yes, I think precisely they are these. Determines the difference between him being in a position of having two counsel qualified in the criminal law field to assist him in his endeavors, and as he stands right now, he is returned to the medical facility in the county jail, unable to effectively represent himself. He's not in court examining witnesses now. He's not trying to charm the jury or even talk to them. And he wasn't even allowed to comment on the publicity order even after he had been designated as counsel by the court. And I think he stated that his mind is a little bit more complex than is read by the judge. He has not taken the position that he feels he can handle the whole lawsuit by himself. He feels...
What is the difference when you go to trial? Will you be there to give him all the help you would if you were in the record as the attorney?
Well, I'm not sure that's so, because the indication is here today that we would have no standing. He didn't even recognize us as advisory counsel if we were to be demoted from the original request. And so consequently, if we were to come in the courtroom, I assume that we would not be in the position of representing Mr. Manson.
Wouldn't all this be avoided if he simply had a competent attorney?
Which question shall
Wouldn't all this be avoided if he simply had a competent counsel to defend him and not defend the case himself? Wouldn't that all be avoided?
Well, as to whether it all be avoided, Mr. Manson's wish that he participate in the trial to the extent that he would like would probably not be carried out. And that would be the shortcoming as far as
What's the need for him to defend himself?
Mr. Manson feels that in view, and I share this point, we don't agree on everything, by the way, but on this point we do. We do feel that there has been such a saturation of prejudicial material in the Los Angeles community that he cannot receive a fair trial here and probably not elsewhere. And that if he has to go to the trial, however, we feel that there should be some attempt to try to combat this. And if he sits over there as a limp, metallic, demoniacal figure, as painted on, say, the front page of Life magazine or in that starry-eyed picture in the Los Angeles Times, I don't think he has a chance. The jury can't identify with him. They won't be able to see him as a human being. He has been brutally dehumanized in the press, and we wish to resuscitate him at trial by letting the jury understand this man.
Life magazine also showed him as a cute little 14-year-old boy.
But he's no longer 14, and Life magazine had him with the long hair and the beard, and I understand he's not been permitted to shave, by the way. I'll just throw that in.
What more could Judge Keene have done? What more could Judge Keene have done?
Has he told you at all what this comment was about the gag rule? You know what that was all about? What he wanted to tell the judge?
I don't know precisely what he was going to say, and that's usually the situation when Mr. Manson comes to court. But I know that his position is that there has been a mountain of one-sided information presented, and that to impose a gag order, after all that has been done, effectively prevents him from being able to obtain a fair jury in the community. And I think he feels like he should have a chance to state his side.
Why his distrust for lawyers? Why does he distrust lawyers and the law?
Well, that's a long question, and I myself have advised him to try to place a little bit more trust in lawyers, but it doesn't always work. It's a generalized distrust. He certainly is not distrustful of Mr. Steinberg and myself. He will trust us, I think, more than any other lawyers, but not completely, because his experience of being in prison for, say, more than 21 years, and the processes which led him there, rightly or wrongly, have led him to the conclusion that lawyers are all part of the establishment and that lawyers are the explanation for these things, and that's the way he feels. And I think that the critical fact here, just as the issue in court today is not just justice, but the image of justice, and it looks bad, it smells.
If he feels this way about you, Mr. McKisick, why didn't he tell the judge this, if he feels that way about you and Mr. Steinberg?
Well, I think by designating us as his legal advisors, he has indicated he's had a shower of attorneys who visited him. Mr. Steinberg and I were asked to visit him. I was asked to represent Mr. Manson. I did not solicit him. And by designating us, I think he's indicated the twosome that he has confidence in.
Well, what difference does today's action make in what you will be able to contribute to this defense?
Well, I'm in a dubious state because I do not know whether I could appear in court with him, argue motions for him as I feel that I must, and Mr. Steinberg. Investigation, we have Michael McCowan, a skillful investigator who did the Sirhan case, who has been here for a week, ready to start the investigation in this case, ready to interview witnesses. I want to move for a change of venue. He doesn't have we have a whole organized plot for trying to show that the prejudicial community will prevent a fair trial. We can't effectively do this. We don't know what our standing is in court. That's the primary thing.
Can you appeal today's ruling?
Well, I don't think technically under the laws of appeal that anything would be heard right now. We could seek a writ, which is sort of the same thing, and state certain propositions in it, and a hearing may be called for, but it would be months before there would be any ruling. And this man can't afford to go without counsel for months.
Mr. McKisick, can't he call you over to his jail cell and ask your advice on the moves to make? Can't he also ask your advice in court on what to ask witnesses?
Certainly he can, but if the judge, he may say, for example, I don't understand this, McKisick. I'd like you to explain it for me. And I say, Judge, here's the point. The judge will say, you're not counsel, Mr. Manson is. Sit down. Now, where does that leave us?
What are you going to do next specifically?
Visit Mr. Manson. Other than that, I really don't know. I think, I do feel there's been egregious error here, and as is the situation every time he comes into court, we don't know precisely what's going to happen. I assume that we will talk with him and discuss, in view of the judge's ruling today, the advisability of a course of action. I do know this, that had Mr. Manson been turned down on his request to go in pro per, he would have indicated to the court that he desired myself and Mr. Steinberg to represent him as attorneys of law.
Do you think he might change his mind?
No, I think his back is against the wall at this point. And I think that his distrust may well generalize. That's what I'm afraid of.
Luke, he appeared in court today throughout the 45 minutes that the judge talked to him, that nothing that anyone said to him really got through. I mean, he had made a remark a couple of days ago, well, I have an open ear, but he didn't appear to me to have an open ear. Can you describe his feelings on that?
Well, I suppose that when you don't end up with the same conclusion as the judge and the illegally court-appointed attorney, it is assumed that you haven't taken their advice because you rejected it. Now, I suppose that history will probably debate the question as to whether he should have done what he did, and I think there'll be a lot more that'll happen in this lawsuit. But I think he listened to what had to be said, and his position is that, given the posture of the case, and this is perhaps an error. This man. Everybody else doing
Sorry.
I was thinking of that.
Nobody's allowed to stand, so you'll have to wait out there.
Oh, marvelous.
You made that letter clear.
So good to see you.
Did you see him?
Yes.
Did you see him? Come on, say I think we're late, is the thing.
Well, next time we'll meet earlier. They should have it at 6 in the morning so we can stay up longer. Yeah.
Well, then forget it. I mean, the other side of the door? Yeah. Oh, we can't do it? Forget it, Carl. If you can't do it, you can't do it. So you do it.
Crowded in here?
Okay. Harvey, he says he's been in solitary.
Light on the other stuff.
Well, I went to see him yesterday.
What raised that light, Harvey? Harvey. And you weren't aware of the fact that he was in solitary?
I haven't seen him. No one has seen him.
Well, when he appeared in court today, this was the first time he came into court in Los Angeles wearing his wig. And he had a beard. He said he had been in solitary.
When was the last time that you saw him? We don't know.
A couple weeks ago.
I don't know. That's my sound man. I can't hear. What's going on? No.
Does Mr. Salazar prepare any documents?
What are you doing, Sam?
You want to get in here?
Yeah, whatever's going on.
What kind of testimony do you think you'll be able to offer?
Come on, get in here.
Can we put this mic in there?
I don't know. Couldn't get through
Well, he said he was in solitary. We have no information one way or the other. Perhaps the sheriff's department can tell us. If a defendant in custody violates the rules of the jail, they must be punished accordingly, whether he's pro per or not. I don't know what he did, but he said he was in solitary, and if that is so, then you must...
What does the writ of habeas corpus ask?
Vince, would you tell him what the great writ asks?
Well, a typical writ of habeas corpus asks the court to demand of the sheriff, actually, not the district attorney, to demand of the sheriff that the sheriff bring the defendant to the court and have the sheriff state to the court the legal cause for the defendant's incarceration. Mr. Manson's writ did not really say that. The only issue he addressed himself to in that writ was the fact that he wants to be represented by an attorney, but he also wants to represent himself. So the language of his writ was certainly not typical language.
He seemed nervous today. Why do you think he was? He's a little more on edge today.
Well, you'd have to ask Mr. Manson about that. I would say this, however, that today was probably his first confrontation with the prosecution. Here Heretofore, his confrontation has basically been with the judge and the court. Today, he made a 995 motion stating that there was insufficient evidence for the grand jury to indict him on 7 counts of murder and 1 count of conspiracy to commit murder. Of course, the prosecution had to then go forward and tell the court why, in our belief, there was sufficient evidence to indict him on.
This was not a normal kind of a procedure. Several times he made the statement, for example, that the testimony given by Susan Atkins in no way affected him.
Well, he can say anything he wants. It's a free country, and if he wants to say that he heard a cow speak the Spanish language, he can say that. Query whether anyone has to buy anything that he says. So the fact that he said it is not that much.
He said it in a fashion as though that testimony that she had given to the grand jury would not jeopardize him in the trial ahead.
I think what's happened is that he is confused her testimony with her words. In other words, he says those are just words. Well, witnesses' words are testimony. A lot of people think that evidence requires fingerprints or motion pictures or one of the victims to have remained alive to testify. We get testimony from the words of witnesses, and he couldn't understand how Susan Atkins' words were testimony.
What about this business of taking the baby? She says they threatened to take her baby, and that's why she said all that. What's your reaction to that?
Well, of course, that is absolutely false, and at the trial, that issue will be completely heard and will be dispelled because Susan Atkins' baby was in protective custody long before she testified in the grand jury.
Do you have any comment on the published reports today that there will be an attorney by the name of Salazar from Denver joining in this, and that perhaps all of these defendants will be under one attorney?
No, I just get what I read in the newspapers on that, gentlemen. I've had no contact.
Is that an accurate statement? Do you have any knowledge that would back that up?
I don't know what would happen when the time came.
Mr. Stovitz, how did Mr. Manson appear to you? His demeanor, so to speak, his overall presence?
Well, his flamboyance was gone. He met a judge who wouldn't tolerate any of his nonsense. And as Mr. Bugliosi said, it was his first confrontation with the prosecution, and he knows that the time is drawing near now for trial.
He looked tired.
Oh, probably was.
Indicated a solitary confinement.
The judge
I don't know about
seemed less
that.
inclined to let him ramble on, as has not been the case in the past with Judge Dean and Judge Dell. Is this a new technique of dealing with it?
Don't forget, Judge Lucas has got 6 or 7 other cases to hear today, and he wants to get on with his business, just as you gentlemen want to get on with yours.
Mr. Stovitz, would you explain for us very briefly, sir, exactly what happened in court today from the beginning?
From the beginning, Mr. Manson came into court, and he stated he was in solitary. We don't have any evidence one way or another.
He said as if he had been in solitary.
It looked to me as if he had been up all night or tired.
Thank you. We've appointed the team murder trials. They're both competent, dedicated men, and they will effectively represent the interests of the people in this matter. As you know, 3 people have already been arraigned: Miss Atkins, Miss Kasabian, and Miss Houghton. Mr. Manson will be arraigned today. Miss Kasabian and Miss Houghton have asked for and received a continuance until December 22nd for plea, Miss Atkins to December 16th. 2 others, Mr. Watson in Texas and Miss Krenwinkel in Alabama, are resisting extradition. The extradition papers have been prepared in our office and are on Governor Reagan's desk this morning. The authorities in Texas and Alabama customarily and traditionally are efficient and cooperative in extradition cases. We do not anticipate any problem. We believe that the other 2 defendants now out of the state will be here within 3 weeks. We, of course, can't guarantee because this is not subject to our control. Once all of the defendants have been arraigned, and assuming they enter pleas of not guilty, our office will be prepared to go to trial within 60 days. Any delay beyond the 60-day period will not be as a result of any action on the part of this office. The transcript of the grand jury testimony is being now typed to you, but meantime, as I say, if you want to see it, you better arrange to get your own copies through the Secretary's office of the grand jury.
Question at this point, Mr.
You want to ask about the gag order?
No.
Okay.
I want to ask about the transcript.
All right. His order. There has been a gag order imposed in this case, which for all intents and purposes is identical to the one imposed in the Saran case. We opposed the order in that case and sought a hearing before the Supreme Court. We were not given the hearing. We felt the gag order was wrong on several counts. We thought it was legally improper. We thought the judge excluded, or I should say, the judge exceeded his authority. We thought it was also not in the best public interest. Our legal position is very well set forth, we think, in our brief filed before the Supreme Court. If you want to refresh your recollection as to our position with respect to the gag order, Mr. Littman, our press secretary, has extra copies of that brief which you can borrow. Beyond the legal points involved, beyond the fact that we resented and resisted at that time the imposition of the gag order, feeling that the judge exceeded his authority, we thought there were stronger reasons why it should not have been imposed based on public policy. You'll recall in the Saran case, a young woman announced on national television that she'd seen a girl wearing a polka dot dress running from the assassination scene with two foreign-looking males. She further stated that she'd heard this person say, "We got Kennedy." The story was broadcast and printed nationwide. Public speculation turned toward a political conspiracy. In fact, the story had been fabricated by the girl for publicity purposes, but the district attorney was forbidden by the order to explain this to the public. Many of you gentlemen attended a press conference at that time where a reporter from the Middle West asked me, "Is there any truth to the rumor, Mr. Younger, that President Nasser of Egypt is involved in a conspiracy and that there are some Middle Eastern governments who have actually financed this assassination?" That, of course, was an absurd rumor, and public interest demanded, in my opinion, that I be able to say at that time, there is not a bit of truth to it. That's absurd. There's no conspiracy. There's no Nasser or Middle Eastern government involved. However, you will recall I was forced to respond under the gag order by saying no comment. And you can imagine the headlines in that Middle Western paper. The headlines were Nasser involved ? DA says no comment. Now, I felt and still feel that that was an outrageous imposition, and I thought further it was very damaging to the public interest at a time when people all over the world were speculating about conspiracies and otherwise. Our attitude on the gag order has consistently remained the same and is still the same. We resist it and we resent it. I have made it clear in the past that at the appropriate time I was going to deliberately violate the gag order and force the Supreme Court of the United States to determine once and for all whether a court had the authority to impose this kind of an order. However, I have indicated, and I indicate now, that we do not consider this an appropriate case to test the order. We will test it in a relatively simple criminal case involving one suspect and one victim. We do not consider this the right time, the right case to test the order. We will abide by the judge's order in this case.
Do you feel, Mr. Younger, that the rights of the defendants to a fair trial or your ability to prosecute successfully have been impaired at all by the publicity given to the case up to now?
No, sir. I believe there has been wide publicity given. I think for the most part it has been responsible. Beyond that, some of you men deliberately sat on this case for some time to give the law enforcement authorities an opportunity to complete the investigation. The fact alone that wide publicity is given to a case does not, in my opinion, by itself mean that the parties involved can't get a fair trial. I have always had greater faith in the jurors' ability to discriminate between something they read a year ago in the newspaper and evidence presented to them in court. As you know, each and every one of them, before they sit on any criminal case, takes an oath to abide by the instructions of the court, and one of those instructions is to the effect that the jurors must disregard any previous information they may have obtained, set aside any previous opinion they may have held, and base their decision entirely on the evidence to be presented at the time of the trial. And in over 25 years in this business, I'm of the firm belief that about 99 9/10% of all the jurors take their oath seriously and do just that.
Is there a likelihood that this might go one step farther, as now is the case in affecting trial? The day-to-day coverage of the trial may be banned as well?
That, of course, is the problem with any restriction on our office or on your media. And that's why, as I say, we are anxious at the first opportunity that we consider to be an appropriate one to test the order. But if these orders go unchallenged, the next one will be from another judge in another case will be more sweeping.
Well, is that a concern of yours right now about this case?
Well, it was a concern of mine at the time of the Saran case. Any of these restrictions. Let me make one thing clear. None of you gentlemen have ever heard or ever will hear me, and I hope none of my deputies, make any comments concerning the evidence to be presented at the time of trial. I've never said, oh, so-and-so's guilty, it's a dead bang case, it's a cinch, he's lying, we've got... Just say again that it should be obvious to everyone, certainly lawyers and laymen also, that this is not going to be the simplest criminal case ever tried. And I'm not speaking of guilt or innocence, I'm just speaking of the mechanics of the trial. When we test the gag rule, we don't want a lot of other issues or problems in connection with the case. And we feel, incidentally, not the same compulsion. There were to be able to give you information as we did in the Kennedy case. In the Kennedy case, there were many false rumors that got started that could not be eliminated by your reading the transcript. We wanted to be able to tell you that this was a false rumor or that was a false rumor. We couldn't do it. In this case, when you read the transcript, most of the false rumors that have been circulated to date can be dispelled in your own mind by reading the transcript.
Oh, well, Mr. Younger, you say you're going to test inaccuracies that have been reported in the press. You said this will be cleared up by reading the transcript. What do you mean?
I mean just that. I won't say many because you might think many means one thing and I might think many means another. There have been a number of rumors disseminated in the press and in the media, otherwise, that as the transcript will show to have no foundation in fact.
Mr. Younger, suppose I ask you.
We are not targeting in on them any more than we are any other group that seem to think it's a wholesome, legitimate activity to collect machine guns, sawed-off shotguns, grenades, and so forth. But wherever we get evidence of that fact, we'll do everything we can to obtain the weapons and prosecute the people who had these illegal weapons, without regard to who they are. We'll do our best. Yes, sir.
The black representatives, elected representatives, namely Murph Diamerly and Bill Green, this morning held a press conference and decried the fact